Good afternoon, everyone. Welcome to this afternoon's webinar. I can see everybody joining. These numbers will tick up over the next minute or so, I know. It's good to see some familiar names crop up and definitely some people on the call whose names I don't recognise that. So welcome to ISE if you're not an ISE member. It's lovely to have you here. My name is Sarah Hathaway. I am the Joint Chief Exec for ISE. We have two of us, obviously. My side of ISE is supporting all of our members, whether that's through webinars, events, all the other benefits that are part of this. So very happy to be here. I know this is a very important subject for so many of you. We're expecting somewhere in the region of about 400 attendees, so one of our bigger ones of the day. In a moment, I'm going to hand over to our two experts for the day. Just to say, please, that if you would like to put your questions as we go through into the Q&A box, not the chat box, that would be really helpful. It'll just help kind of monitoring of that. Please use the chat box, say hi to people if you recognise them, all the rest of it. But if you can put the questions in the Q&A, that would be really helpful. So without further ado, Carl and Kiran, if you'd like to join us, I'm going to hand over to our two experts from Paragon Law and ask you to kick off the presentation. Thank you very much.
Thank you, Sarah, for that introduction. So I'll start with sharing my slides, if I may. Okay, Sarah, can you see that?
Yep, absolutely lovely. Thank you.
Fabulous. Good afternoon, everyone. We have a lot of content to go through today. As I was saying to Sarah, unfortunately, I cannot do this presentation with pictures. It's very dense with slides and content. And what we're going to be focusing on is what the significant changes have been in 2024 and what that means for businesses and workers. The key topics that we're going to be focusing on are these here. We will also gaze into the future, which is constantly changing with, certainly immigration becoming quite political at the moment in the election campaigns. And, only over the weekend, Rishi Sunak was saying that if the Conservatives are re-elected, they'll be introducing the immigration cap on skilled workers again. So we'll also consider some of those issues that are definitely going to happen and may happen as well. We'll also focus on some other visas that might be applicable to some of you as recruiters, and then we'll finish off with how to avoid discrimination claims in your advertising and recruitment selection. I have my colleague Kiran, who's on the call with me, and she'll be answering your questions in the Q&A. So please do make sure that if you're not sure about something that I've said, or if you have a follow-up question, to ask that question in the Q&A, and Kiran and my colleague Andy will do their best to answer those. And then throughout the presentation, we will stop at sort of strategic places to ask if there's any questions, or to take certain questions from the Q&A, which may be important to share with everyone. So the first change, and I'm going to go in date order here, and as I go through these slides, some will be applicable to all of you, and there'll be some slides that may not be applicable to your organisation. And if that is the case, take the opportunity just to zone out and rest your eyes as we're going through the presentation, then come back in when there's something that's relevant. So the first change on the 1st of January 2024 was the change to international students being able to bring their dependents to the UK. So international students that enrolled on courses from the 1st of January are unable to bring their dependents to the UK. The exception to that is students that are either studying a postgraduate research program. So for example, if it's a master's or an MSc course, of which 50% of that course is research-based, or if the individual is doing a PhD or similar type of program as that, then dependents can be invited as under their visas. Also, students who started their course before the 1st of January will still be able to invite dependents. And student dependents who are already here or who come through these two exceptions here will be able to work in the UK without any restrictions or requiring sponsorship, and they'll be able to continue to extend their status so long as they meet the requirements of the next stage of the visa to which they'll be extending. I did also want to focus on one change that occurred on the 17th of July 2023, and that change requires international students to complete their courses before they're able to switch into any of the work groups that we're going to discuss. Prior to the 17th of July, if an international student was offered a role, they could stop being an international student and just simply switch. But that now the key with students on degree or higher courses is that they must complete the course. However, as recruiters, you can assign a certificate of sponsorship before the course finishes, but you must ensure that the work start date that's stated on the certificate of sponsorship is one which is after the course completion. It's therefore important for you as recruiters to ensure that you're engaging with the university and obtaining evidence of course completion. Note that they don't have to successfully complete the course in order to switch to the skilled worker route, but that they complete the course. This is different to the graduate route, where the international student will need to provide confirmation that they've successfully completed their course. With PhD students, there's a slight exception. They don't have to complete their course in order to switch to the skilled worker route or any other work-based visa, but they must complete at least 24 months of their PhD in order to then be able to switch to the skilled worker route. And again, as recruiters, you will need to know when that 24-month mark has been completed in order to put the relevant date on the certificate of sponsorship. This slide is really here for those of you that represent global businesses where you have sister companies overseas, your subsidiaries, or your parent companies. Changes to the visa changes on the 31st of January. One significant change, which is welcomed by many businesses in the UK, is that your colleagues from overseas are now able to come to the UK in order to be part of projects that are consulting or advising UK-based clients or customers. The previous rule was that they could only come and consult and advise internally to their colleagues within the business, but now you can have them on projects where you're consulting outside of the organization, so long as the contract that you're serving is with the UK company. Another change was that visitors are allowed to work remotely whilst in the UK on a visit visa, so they can continue to work on their overseas employment, provided that this is not their primary purpose of their visit. So what this means is, for example, if they're here on a family visit or they're here as tourists, they can still, take the odd meeting on behalf of their overseas employer in the UK, or indeed switch their computer, their laptops, and communicate with colleagues and do some work. These two are quite often interrelated, we find, where individuals are coming in on as intra-corporate transferees on the visitor visa. Quite often the question will be asked of us whether their spouse or unmarried partner can come with them, and would they be able to continue to work for their overseas employer whilst the main worker is working on a project, a UK-based project. So the answer to that is now a definite yes. Also, experts invited by a UK-based organisation for a permitted paid engagement can visit for up to 6 months. The previous rule was only 1 month, but they must complete their engagement within the first 30 days of their arrival. So this could be, for example, guest lecturers or guest speakers that are coming to your organisation. To do a permitted paid engagement, they must complete that within the first 30 days, but then they can stay here for up to 6 months. There was also a change for academic scientists and researchers who can now carry out research in the UK as part of a project related to their employment abroad. So they no longer need to come to the UK to do independent research on a sabbatical, but they can come as part of a university project to work on projects that maybe two universities are working on in the UK. I won't labour on this slide too much, but this is really for those of you that are representing law firms today. And that is that overseas lawyers can now come to the UK and advise on UK-based legal matters and advise and appear in all these types of arbitrations, conferences, teach. They can attend court and litigate on behalf of their UK-based client, whereas the previous rule was that overseas lawyers could only come to the UK to advise on overseas international litigation and international transactions. So they can now very much be part of the UK team advising on UK legal matters. So a change you will all know that happened on the 6th of February 2024 was the increase to the immigration health surcharge. Quite a significant increase. You'll see here for adult applicants, this changed from £624 to £1,035, and for dependents, children under the age of 16, it increased from £470 to £776. So if you look at this, for example, in terms of what that means for a 5-year sponsorship, that's increased for the main applicant from 3,120 to 5,175. If the person you're sponsoring has a spouse or an unmarried partner, then you'll see what the increase there is. If the main applicant has their partner and 2 children, and you'll see what the significant increase there is. In terms of the cost for sponsoring an individual, we've split this in 2 sections. So you'll see here what the costs are that the employer is responsible for, and what the costs here are that the individual is responsible for. So as employers, obviously you need to apply for the sponsor license and the application fee that relates to that. The cost of a certificate of sponsorship is £239, and then the immigration skills charge, depending on the size of your business, is going to be £1,000 per year of sponsorship, or £364 a year of sponsorship. Now, if you were to sponsor an international student directly and switch into the skilled worker route, the immigration skills charge will not apply, which means that you can benefit not only with the new entrant salary, but also, which I'll cover in a later slide, but also there's no cost to the immigration skills charge. The immigration skills charge will be applicable if the international student has already switched to the graduate route. So these are the fees for the individual, the immigration health surcharge. Obviously, if you're recruiting someone within one of the healthcare worker visas, then the immigration health surcharge is not applicable. And then you'll see what the visa fee is for a 3-year visa and the cost for any visas that are going to be over 3 years, which is 1,420. Now, when advising clients, quite often, depending on the seniority, actually, on the individual that they're going to sponsor, quite often, the more senior the individual, the more likely that our client will meet the cost of the individual's fees as well. And certainly, if our client does choose to do that, if you do choose to do that, we would advise that you add a clawback clause in the contract of employment, which will allow you to recover a percentage of the fees that you paid for the individual based on how long they've been with the organisation up until the date that they left your sponsorship in order to either return home or take alternative employment. Because as you can see, if you're going to do that, it can be a significant charge that you're paying. So it's good to sort of safeguard some of that in the event of a premature end of employment. Now, on the 13th of February 2024, the codes of practice on illegal working were also changed, meaning that if you are found to be employing an illegal worker in the UK, the civil penalty has increased from £20,000 to £45,000 per worker. So a significant increase. And if you're found to be a repeat breacher, then the cost will be £60,000 per worker. It's something that you need to take note on, because if there's one thing that the UKVI have certainly picked up activity on is visiting businesses, either as part of the UKVI audit of your sponsor license, or just as part of choosing certain sectors within a certain area. So, for example, they may choose hotels in the East Midlands or retail outlets or whatever it is. And what they'll be asking when they visit your premises is to look at right to work documents for workers that you employ. The consequences of getting it wrong is obviously the civil penalty that you would have to pay per worker. You also need to take note that employers are named and shamed online by the Home Office. So obviously there's a PR and reputation risk. And if you are a sponsor license, it's likely to trigger a wider audit. And obviously that if you're going to have a sponsor license audit, there's going to be business disruption there. We tend to do a whole webinar on this, so I can't go into this in too much detail, but I would recommend, if you haven't reviewed your right to work policies, that you carry out a review and audit of your right to work checking processes and procedures. Who was responsible for the right to work checks? What are the different right to work checks that you need to carry out, and how is this evidence retained by your organisation? You should have a written policy. So if the main person who carries out right to work checks is on annual leave, or has left the business, there's someone else who can step in and review your policies and take the process forward. And the way to highlight that for you is this true story back in 2012, which involves Tesco, which I'll read to you here. So back in August 2012, the UKVI arrested foreign students for alleged breaches of visa conditions following overnight raids at a Tesco's office in Croydon. Tesco was fined for 23 of its workers for illegal working. This was because, as part of their student visas, those employees were allowed to work 20 hours a week during term time, but some of those employees were working up to 70 hours per week, which was in direct breach of their specific visa conditions. As the employer, Tesco should have conducted right to work checks, which would have flagged these work restrictions, and processes should have been put in place by Tesco to make sure that students did not breach those conditions. The consequence of that was that those in breach were arrested and deported, and Tesco were fined £115,000 per worker, when the fines in 2012 were £5,000. And had that occurred today, with the £45,000 that it's increased to per worker, they would have had to pay a fine of £1,035,000. This is particularly important if you're a multi-site business and you find, for example, if you're a retail business and your store managers are carrying out the right to work checks, you need to make sure that they're updated on what the current checks are, and audit their own processes to make sure that it's being done properly. We were acting for a very large retail outlet, which their store managers were just failing to carry out right to work checks, and the only way that we were able to deal with that was to make it as part of their KPIs and disciplinary process if they failed to do it. And it was only then that the store managers stepped up and ensured that the correct documentation was obtained before the individual started work. So look at what's best for your organisation and take on board that these types of rates are on the increase as part of the government strategy to reduce bogus employers and also to reduce migration generally. A change on the 13th of February was in relation to supplementary employment. So you may be aware that skilled workers, those on a senior or specialist worker, and those that are on the government authorised schemes are able to carry out 20 hours of supplementary employment in addition to the sponsored work that the individual's carrying out. And if you're going to be an employer that's providing supplementary employment, there's a requirement that you're ensuring that the employee that you're going to employ for the supplementary employment is not breaching the terms of their sponsored employment. And what that means is that you will need to check that firstly they are being sponsored, so you would need confirmation from their from the employer that's sponsoring them, and that secondly they're not going to be working during their regular working hours as per the contract with their sponsored workers. So you need to make sure the supplementary employment is outside of their normal working hours. On the 13th of February, the rule was changed. On the 4th of April, the rule was changed with regards to this, that the individual does not need to just be able to do supplementary employment in shortage occupations, but they can undertake this work in any type of occupation, be it whether it's related to their sponsored work or any other employment. So the other point that you may want to think about here is whether you want your sponsored worker to be able to take on supplementary employment. Perhaps you don't want the individual to be working for a competitor or for a business in a similar sector, or you're just generally concerned about their health and well-being in taking extra 20 hours of work beyond that which they're doing for you. And therefore, if you do have concerns of that sort, you may need to consider putting relevant clauses in the employment contract to prevent people from doing that. So a change on the 22nd of February 2024 was to the UK electronic travel authorization. Up until November 2023, the UK VI were looking at this with Qatari nationals only, but this has now been expanded to the rest of the UAE and Saudi Arabia. And the UK are going to introduce this by the end of 2024 for all non-visa nationals. So that's all non-visa nationals are those individuals that can come to the UK and present themselves at the port in order to enter as visitors. So those nationals that are from visa countries will still need to apply for visas to enter the UK as visitors in the usual way. And the electronic system for travel authorization, the UK electronic travel authorization scheme is very similar to the US ESTA scheme, meaning that it's a requirement to seek authorization to travel to the UK and not permission to enter. The permission to enter will be given at border control at the port of arrival. To apply for this, you would have to do so, your colleagues will have to do so online or via an app that the UK will be introducing. The cost will be £10 and a decision will be given within 3 working days. Anyone who needs to travel to the UK urgently must apply for an ESTA before they travel, for the ETA before they travel, but they can travel to the UK whilst waiting for a decision. We don't know what the definition of urgent travel at the moment is, so that's something that we're going to have to keep an eye on what those exceptions are where they can make their application but travel before a decision is given. The ETA will last for 2 years or until the date that the traveller's passport expires, whichever is sooner. Anyone with an ETA approval can travel to the UK as many times as they want during those 2 years, but they still will have to comply with the visitor rules at the port of entry. A change that occurred on the 5th of March 2024 was that sponsors no longer need to report changes to hybrid and remote working. And so really what this is the Home Office recognising that remote patterns and hybrid working is now commonplace. And what the Home Office has done on the 5th of March has provided greater clarity. So employers no longer need to report if a sponsored worker is moving to a hybrid working pattern. However, you do need to report if the sponsored worker is working is going to be working entirely remotely, i.e. they're not having to attend your office or a client's site. And in this type of scenario, if you do make this kind of report, you will have to justify why sponsorship is required. If that individual is able to work from home and not be office-based, why have you sponsored the individual? Why can't they remain in their country of origin and work for you from there? So basically, in order to avoid that type of scenario, to have to provide that type of justification, I'd certainly recommend that you have some level, be it on a monthly or a weekly or fortnightly basis, where they are sort of touching base with their line managers or their team within the office. You must continue to report where there is a change in work location, or where your sponsored workers are based on client and customer sites. You must report every time they're going to be on a new client site or customer site. If there's no requirement to report on, the requirement only here is to report on a worker's regular working pattern. And that means you don't have to report on occasional changes. So if, for example, you have a sponsor, again, let's use the retail example. If you have a sponsored worker that's working on your in your retail unit on Oxford Street, and on a particular day you require them to work on, at your Tottenham Court Road site, there's no requirement to report those kind of occasional changes. It's only where there's a change to the regular working pattern. Again, you should note that the UKVI do carry on-site and remote compliance orders, and therefore you must keep records of your sponsors' workers' work patterns and work locations, and be able to demonstrate compliance with regards to working patterns. Okay, Kieran, do we have any questions on that before we go on to the skilled worker route and changes to the 4th of April?
Okay. Questions we have are focusing very heavily upon the end date of the course. So we've got a lot of questions and concerns about what the end date of the course is. And I think this is primarily for the students who are on the seminar. So basically, when you're issued with a CAS, a Confirmation of Acceptance of Studies, an end date for your course is recorded. That's the end date according to UKVI. I'm not saying that the end date can't change, but if it is to be changed, so you submit your dissertation early, your course completes early, the university will then need to report that as an early completion. Then any subsequent letters that they issue you with will have the earlier date on it. But if it's a question of the end date on the course, on the CAS, versus the end date on the letter from the university, then obviously it's the end date on the CAS, because that's the date that UKVI know about. That's the date that's been given to UKVI. So in the ideal, they should be the same. So if you change the end date on the CAS, the letter from the university should have an updated end date. So there does seem to be some confusion as to exactly what the end date is, especially where we submit anything in early. So for your information, yes, the end date can be changed, but it has to be changed on the CAS, so it has to be reported, and then any subsequent letters also need to reflect the new end date. One other question from Ruhi, and thank you for drawing this to our attention, is that so when we're talking about working full-time, under the student rules in respect of work, it basically says, and I think this is something that we'll look at in a bit more detail, it's suggesting that where an application for switching as a skilled worker has been submitted, so a student who makes a valid application for permission to stay under the skilled worker or graduate route may start employment in a full-time permanent vacancy, either up to 3 months prior to the course completion date for the skilled worker route. So it's suggesting that students can work full-time 3 months prior to the course completion date. That's in contradiction to the skilled worker visa guidance. It's in contradiction to other right to work guidance. So I would not at the moment be looking at that. Tal and I will sit down in more detail and have a look at that, and hopefully provide you with a bit more detailed guidance as to where any potential contradiction is coming in. But from if you are, and the guidance on a skilled worker visa is very clear, if you are a student who is switching into a skilled worker route, the start date, the work start date on that for you to be able to switch into a skilled worker must be after the course completion date. So not 3 months prior to your course completing. Okay, so they are the main questions that I'm going to just deal with at this stage, and then we can have a look at any other ones at a later stage.
Thank you, Kieran. So we'll now move on to the skilled worker visa and the changes to this route on the 4th of April. Just by way of summary about the skilled worker visa, so the eligibility requirements for an individual to be able to switch to the skilled worker visa is that they must have a valid certificate of sponsorship from an organisation that's registered as a sponsor with the UKVI. The role that they've been sponsored for must be at least RQF level 3 or above, which as recruiters, you will be looking at the standard occupation codes. And they must be paid a salary of at least 38,700 or the going rate salary for the relevant standard occupation code, and whichever is the higher of the two. And there are some exceptions to where lower salaries can be paid, which we'll cover in later slides. The individual must also be able to satisfy the English language requirement. And generally, if you're recruiting international students who've graduated from a UK university, they'll satisfy that. And then the individual must also be able to satisfy maintenance, which is show that they have evidence of funds of £1,270, which has been in the individual's bank account for at least 30 days prior to the date that they submit their visa application. But sponsors can also certify maintenance on behalf of the individual also. A visa can be issued for up to 5 years initially, but it can be extended after that. And then after 5 years, the individual can be paid, can apply for indefinite leave to remain, so long as they are being paid the going rate salary for the relevant occupation code that relates to their sponsorship. A point that we've noticed that many employers miss is that the salary, the going rate, the salary that you're going to be paying the individual must be based on a 37.5-hour week and must not include any bonuses or allowances. So, you know, whilst the individual can work more hours, but the basic salary that you're putting down on the certificate of sponsorship must be based on a 37.5-hour week. As we've said in the previous slide, they can only work in the job for which they've been sponsored, and plus 20 hours additional employment. And the individual can bring their dependents to the UK, and dependents can work without requiring sponsorship. So the changes on the 4th of April were to the general salary. The general salary is the floor salary, which must be paid in order for sponsorship to be eligible under the skilled worker route. And you'll be aware that that increased from £26,200 to £38,700. And the other change was to the standard occupation codes. Andy, if you could share a list of the skilled worker occupation codes in the Q&A or the chats. And what the changes here was that the codes changed from the 2010 codes to the 2020 codes. And with this, a number of codes had their salaries changed. So there was a significant increase of salaries throughout all codes. And also a number of codes also totally disappeared and were amalgamated into other codes. So in terms of the reductions to the general salary, so where you can be paid a lower salary than the 37,800 or the going rate salary for the occupation code are these here. The first one is new entrant. So if someone is a new entrant, if they're switching from the student visa to the skilled worker, or if they're switching from the graduate route to the skilled worker visa, or if they're going to be under the age of 26 at the date of their application. So it's any one of those three things, and the person will qualify for the new entrant salary. The floor salary for this on the 4th of April increased from £20,960 to £30,960. And in the scenario where you, as the employer, can pay the individual 70% of the going rate salary as per the SOC code 2020, so long as once you've applied the 30% discount, the floor salary does not go below £30,960. if it does go below that, then you're going to have to increase the salary to this floor salary level. The other exception is PhD that's relevant to the role. So if you're sponsoring someone who's completed a PhD that's relevant to the role on offer, the discount there increased on the 4th of April from 23,580 to 34,830, where you're able to pay the individual 90% of the going rate salary as per the relevant occupation code. Where the individuals completed a STEM PhD, science, technology, engineering, or a maths degree, maths PhD, that's relevant to the role, then the discount there increased from 20,960 to 30,960, where you can pay 80% of the going rate salary for the relevant role as per the occupation code. The salary for those occupations that are listed on the health or education occupation codes increased from 20,960 as the floor salary to 23,200 pounds. And these occupations generally are governed by national pay scales, so the NHS pay scales for health occupations and the pay scales for teachers in terms of the education pay scale. So generally, trainees, be it a trainee pharmacist or a trainee optician, should I say, or a trainee teacher, their floor salary would have to be 23,200 in England and Wales, as an example, if that role was an offer to them. The other change that occurred was the Home Office removed the shortage occupation list and replaced that with the immigration salary list. And with that, they took away somewhere in the region of 45 occupations that were on the previous shortage occupation list and reduced that to 23 occupation codes. Again, Andy, if you could share the immigration salary list with the current occupations, I'd be grateful. Generally, with these occupations, there will be some level of discount that's available to an occupation's going rate salary, and we'll look at those by looking at some occupation codes as to see if a discount's available. And there's a floor salary of £30,960 for jobs that are on the immigration salary list. And again, you'll see that increased by £10,000 for salaries that were previously on the previous shortage occupation list. We've got a couple of ISE tables now coming up here, but what we've tried to do here is summarize the previous slides for you with the discounts that are available. So in this column, you'll see what the relevant discounts that are applicable. We've put what the pre-4th of April rate is. And then for those individuals that are going to be sponsored for the first time, this column will be applicable in each case. So you'll be looking at the post-4th of April rates as per the relevant discount. And for those of you that might be involved with sponsored workers who are already in the UK as skilled workers prior to the 4th of April, there are other rates that are applicable, the extension rates that you'll see that are applicable to individuals who are looking to extend their visas under the skilled worker route prior to acquiring indefinite leave to remain. I won't go over this slide too much, but this information will be there to show what discounts are available and which subcodes you have to rely on in each of the cases. Another ISE is this slide here. And what you'll see is when you look at standard occupation codes, is at the top there'll be columns that are listed A, B, C, D, E, and so forth. I'm going to give you an example of this now, just quickly. So this is a subcode. We'll cover this subcode shortly, but you'll see option A, option B, options C and D, and so forth when you're looking at occupation codes. And what the colouring here means is that the occupation codes, the options A to E, are for those individuals that are going to be coming into the skilled worker route for the first time. And then options F to J are for individuals that are going to be extending their status. So they're already in the skilled worker system prior to the 4th of April. And these are the options that will be applicable to them when they're looking to extend their visas. And then option K, where it's applicable on a particular occupation code, will be related to the health and education occupation codes. And this is the point scoring that's related to the salary that the individual will need to meet in order to meet the salary requirements. So what we're going to do now is, in order to explain the last two slides in a bit more detail, is to go through a few scenarios which Kieran will take you through.
Okay, so we have a few scenarios here just to help you understand how to apply those figures. At the same time, just bear with me, there we go. Okay, so we have a fictitious company, Digital Solutions. It's on the SMS, and it has identified the following individuals for the purposes of sponsorship. These individuals, again, they're fictitious individuals, but they will all be applying for the same post, and that is the post of software developer. So we have Anuj, who's currently living in India and has been offered a role as a software developer under code 2134. He holds a bachelor's degree, so out of the UK, in India, has not studied here, has not worked here previously. Then we have Ria, who is an existing skilled worker. So she's already working for the business as a software developer, and she needs to extend her visa. So we know because she's an existing skilled worker, she's come into the system pre-4th of April 2024. So she will benefit from the interim arrangements. And then finally, we have Dan, who is on a student visa and the business would like to sponsor him. So we know he's in the UK. And for the purposes of this, let's assume he's studying a degree level or above qualification and he's on a student visa. So this is the relevant occupation code. Anuj, who's currently living in India, will have to be paid the going rate under option A. So no concessions, no drops will apply, 49,400. Again, bear in mind that the going rate, the general salary under this for someone in Anuj's circumstances is 38,700. The going rate under the code is 49,400. The idea is you have to apply whichever is higher. One of the questions that came up in the chat is, can you prorata down? So you can prorata the rate under the code. So 49,400 can be prorated, but only as low as the general salary threshold. So if Anuj was doing 35 hours, yes, you could prorata it down, but that salary cannot fall before the general, lower than the general. So no matter what happens, no matter how few hours Anuj is doing, he must still be paid the 38,700 because that is the general salary for his option. Ria, existing skilled worker, she will then fall under the interim arrangements and can benefit from the reduction for option F because that's which option will apply to her. And finally, Dan, who is a student in the UK, so we know he can have the new entrant salary and he will also benefit from being able to have the new entrant salary of option E.
Do you want to just mention how long an employer and the individual can depend on the new entrant salary?
Okay,
so
the new entrant salary is for a maximum of a 4-year period. That includes any time you spent on a graduate visa. So if Dan applies now from a student to a skilled worker, he will get a full 4 years. He can ask for a full 4 years on a new entrant salary. If, however, he is applying after he's done his graduate visa and he's used up 2 years of that, he can only get 2 years. And we've got an example of that further in this slide as well. So scenario 2, ABC Financial, they're looking to sponsor the following tax advisors. Marek, who is a Polish national, currently in the UK on a graduate visa. So we know he's in the UK on a graduate visa. Rohan, an Indian national, currently in the UK on a student visa. So both of them are in the UK, one on a graduate, one on a student. And Andre, a Colombian national in Colombia, who's been offered a role as a senior corporate tax advisor. Yeah. So they've all been offered roles as a tax advisor. So this is the relevant code. And under this code, code 2423, taxation experts, you have Marek, who will be offered a salary of 32,410 for a 2-year period. And that is because he can take advantage of being a new entrant because he's on a graduate visa, but only for 2 years because he's already used up 2 of his years on the graduate visa. Next, we have Rohan, who is currently on a student visa. He can again take advantage of the new entrant salary, which will be under option E, but he can do so for 4 years because he hasn't had any time on a graduate visa. And lastly, we have Andre, who's not been in the system before. None of the concessions will apply. He will therefore need to be paid the highest rate going, which is 46,300. Note again, all of these figures are higher than what the generals would be. So for Marek and Rohan, their general salary as new entrants is 30,960. They're going to have to be paid the higher rate under the code. For Andre, the general salary is 38,700, but he will need to be paid the higher rate under the code. Okay, next slide, please. So final scenario, we have ABC Communications. They're looking to sponsor 3 business development managers. You have Mariam, who's in Pakistan, and she is aged 24, not been in the UK before, not held a student visa, so coming in fresh from outside of the UK. David, a Chinese national, currently in the UK on a student visa. And then we have Susan, a Canadian national living in Canada, aged 29. What we're trying to tell you here is that none of the concessions will apply. So then Tal, if you can please take us to the next page. So here we have the relevant occupation code. So remember, Mariam is under the age of 25, so she will be able to benefit from being a new entrant solely based on her age, regardless of having a university degree from the UK, graduate visa, none of that. Solely based on her age, she can take advantage of being a new entrant and can therefore rely upon option E, be paid a salary of 36,750 for a 4-year period, which is the maximum period she's allowed. Next, we have David, who's currently in the UK on a student visa, regardless of David's age. So, even if David is 35, 40, 45, because he has held a student visa to study a degree level qualification or above in the UK, he will also be able to benefit from the new entrant concession and can be paid a reduced salary of 36,750 for a 4-year period. Lastly, we have Susan, who has not held a skilled worker visa before. None of the concessions will apply to her. She will therefore have to be paid the maximum under the code, 52,500. And just before we move on, just to let you know that anybody who has a new entrant concession salary for however long it is, 2 years or 4 years or however long they're allowed to take advantage of that, for the remaining period of the time that they spend on a skilled worker visa, they must be paid the full going rate salary. Okay, so in Mariam and David's case, after they've done 4 years, 37,750, for the last year, their salary will have to go up to 52,500. And just to, again, to cover one of the other questions that came up in the chat, these salaries are not reviewed every year. Because they have shot up so much this April, I don't expect them to go up for quite a while. That's certainly what we're hoping. The salaries before that were in force for quite a while. And so they will not be reviewed every year and go up. Obviously, I can't say for certain, but so far, based upon practice, the salaries are not increased every year, far from it.
Yeah, I think the other point related to that is that the Migration Advisory Committee are going to be opening up a consultation on the immigration salary list and salaries generally, which I'll cover in another slide anyway, with regards to that. Thank you for that, Kieran. On this slide, we just wanted to sort of highlight to you how the SOC codes have changed from 2010 to 2024. And by way of example, if you look at the previous SOC code 2010, which was for design and development engineers, you'll see what the going rate salary was, the new entrant, and this was actually a shortage occupation. This particular code has now completely disappeared in 2020 and has been split into these codes here, which are electrical engineer, mechanical engineer, and so forth. And you'll see what the different salaries there are depending on which type of engineering role you're looking to sponsor, and therefore accordingly what the new entrant salary will be based on the 70% of the going rate. Another example here is business and financial project management professionals. Again, you'll see what the previous salaries there were. And again, this code is no longer in the 2020 codes and seems to have been split into these two particular codes. So if you look at, say, functional managers and directors not elsewhere classified, you'll see the salary there of 69,900. If you looked at buyers and financial project management professionals, the salary is quite a bit lower, as at 52,900, as is the difference between the new entrant salaries. And the reason why I wanted to highlight this is that, quite often you have to look at SOC codes very carefully, and not just look at the first one that might appear to meet the definition of the role that's on offer, and see that as the best fit. But quite often there could be another code into which that same job title and job description that's on offer to the individual could fit. And accordingly, you could then sort of pay the going rate salary or the new entrant salary in terms of recruiting graduates for graduate recruitment programs. At the moment, we're seeing the likes of KPMG, Deloitte, and a couple of other organizations who have publicly come out and said that they're unable to recruit individuals on their graduate programs because of the increase to the new entrant salary requirement. Now, I wonder whether that's because they're looking at this across the board, across the UK, and not just London-based graduates in London-based roles when they're looking at this. And for me, it's actually welcome that they've done this, because it's highlighting to the government and to the Migration Advisory Committee how uncompetitive the situation has become in terms of graduate recruitment, being able to rely on occupation codes and be able, some businesses not being able to pay the new entrant salary, which will be good for when the Migration Advisory Committee open up the consultation to the salary list. But also, I'd impress upon employers to look at the SOC codes more carefully and see whether another code might be more applicable, where the going rate salary isn't as high, and therefore sponsorship not being applicable, and use a code where you can sponsor the individual at the salary that you can meet. So other changes throughout this year and that are likely to happen are, well, one change that happened on the 11th of April 2024, you would have seen in the media that the minimum income requirement for UK-based, those people who've got UK citizenship or indefinite leave to remain that want to sponsor their overseas partner to the UK, they must now show a salary of £29,000. So that increased from £18,600. At some point from now to sort of late 2024, that salary is going to be increasing from £29,000 to £34,500. And then in early 2025, that salary will be increased again from £34,500 to £38,700. As I mentioned previously, the Migration Advisory Committee will carry out a full review on the immigration salary list, and this will be the opportunity for you as employers to engage with the consultation process that will take place. By the end of 2024, the electronic travel authorization scheme, one of the very first few slides that I mentioned, will be introduced for all non-visa nationals. So individuals will need to obtain travel authorization before they come to the UK. And then you should all be aware that by the 31st of December 2024, physical immigration documents are going to be phased out. So biometric residence permits, biometric resident cards, and instead individuals are now being invited by emails by the UKVI, where the UKVI have email addresses of those that they're aware have biometric resident cards, to register online for their e-visas, meaning that individuals will then provide share codes to employers or to landlords, etc., or to banks to show that they have the right to stay in the UK. And apparently this information is also going to be shared by the UKVI with airlines as well. So where you have a colleague that has an e-visa from 31st of December 2024, that if they're travelling abroad and coming back to the UK, the airline that they're travelling on should have information on their system to show that that individual is safe to board because that they have the correct immigration status. I'm not overly convinced that this being a government IT system, that it's going to be as smooth as what the government is hoping. And I foresee, as we did with the EU settlement scheme, that some people are going to be refused to board airlines because the system isn't up to date. And therefore, if you do have colleagues that are traveling overseas on an e-visa, I'd probably recommend that HR provide them with a letter to confirm their immigration status and any, a printout of your online right to work check that you've carried out to the Home Office online right to work checking system, just in case they need it as evidence as to their immigration status. So the other thing that was introduced over the weekend, which I haven't had a chance to update, is that the Conservative government are saying that they're going to reintroduce the immigration cap for skilled workers. You'll recall that prior to Brexit in 2021, there was an immigration cap on skilled worker visas as part of their electioneering. And I guess to compete with the Reform Party, they're saying that they're going to be introducing similar caps. Labour's big plan, which I think is doomed for failure, is that they're going to upskill home workers to be able to do those jobs that employers are reliant on skilled workers on. I mean, that's going to take a generation, and because of the aging population throughout Europe, so there's a global war on talent, it's going to be very difficult to do that. And the other thing potentially that the Labour government are saying is that those employers that are relying on the sponsorship scheme, on the skilled worker scheme, are going to have to provide work-based plans to the UKVI, to the Home Office, to show how they're going to train local workers or rely on automation or other processes in order to reduce their reliance on the skilled worker pool. So we'll see if any of that actually happens post the election. Other changes that you need to be aware of in terms of salaries that happened on the 4th of April is to the global mobility senior or specialist workers. So you'll be aware, so this relates to those of you that have sister companies overseas, subsidiaries, parent companies, and you have a global mobility sponsor license, that the colleagues who are coming into the UK under these visas, their salary has increased to £48,500. Graduate trainees, the salary has increased to £25,410. And those sponsors that have a scale-up license as well, the salary has increased from 34,600 to 36,300. It's very important that you do engage with the MAC once they open up their consultation on the review of the immigration salary list. It's the only way that potentially we're going to impact and make changes. And kind of some of the things that as organizations or as individual businesses that you might want to be looking at when engaging with the MAC is to discuss what impact the new salary threshold has had on your business. Does this new threshold mean that you are unable to sponsor workers because it will make their salary out of sync with home workers? And if you were to increase the salary of home workers in order to compete, in order to be able to then sponsor migrant workers, what will occur there? Wage inflation. If wage inflation occurs, then as businesses, you're going to have to pass your cost to your end customer, and overall that leads to more inflation as well. So it's quite inflationary, this policy of increasing salaries to the extent that they have. The MAC will also want to know if you're asking for salaries to be reduced or to be made more competitive, what have you actually done to recruit from within the resident market, and why hasn't it worked? What else have you done to reduce dependency on workers? Are you training an existing or new workforce, upskilling individuals? Are you relying on automation? But, for example, training local workforce may take a generation for any benefit, and automation may not necessarily be relevant to your sector or your type of work. Do the salaries also do not take, is it the case that the new salaries don't take regional variations into consideration? I certainly believe that to be the case, that they seem to be very London and Southeast weighted, but again, we're having clients in the Midlands and in the North that are saying that they're unable to sponsor individuals now just because of the increase to the going rate salaries. Certainly higher education, where you're able to bring this data into play, your organisations should be also discussing other macro and micro issues such as impact on ageing population, the demographic changes across Europe, the global war on talent, and that current UK immigration policies is making UK PLC uncompetitive and less attractive to talent compared to Germany and Ireland, who seem to be introducing immigration policies encouraging the brightest and the best to come to go to their countries for skilled worker type roles. So also looking ahead a bit more, there's going to be changes in the EU. They're going to be bringing two schemes in, the ESS and the ETIAS. Now the EU entry and exit scheme is proposed to be introduced at some point later this year. And what it will do is automate border control and replace passport stamping, with the primary aim to monitor the limits on non-EU travel, on non-EU travellers staying in the Schengen region. So what you should be aware in terms of your business colleagues that are travelling overseas is that they're only allowed to be in European countries for up to 90 days in any 180-day period. It's a rolling 90 days, and rolling 180 days. But already we've had some clients where their colleagues have been caught out because they've been travelling for a longer period than 90 days in that period, resulting in certainly on a couple of occasions, individuals being refused entry into, I think it was Poland, in terms of the example that I'm giving there. So you also need to make your colleagues aware of the 90 days in the 180-day period. And that includes business travel or any holidays that your colleagues may have had in Europe, the total of 90 days travel, regardless of the purpose of travel. So the other system that the UKVI are going to be introducing is, the European Union are going to be introducing is the European Travel and Information Authorisations system, and that's going to be very similar to our ETA system and the USA ESTA system. So as UK nationals, from some point in mid-2025, we will first need to complete the ETIAS system before we travel to any countries to Europe, be it for holiday or for business travel. We're now seeing an increase in compliance visits and remote audits by the UKVI. For example, you'll see here that in the first half of, these are the only figures that we have at the moment, in the first half of 2023, 214 licenses were suspended through UKVI audits, which accounted for about a third of the visits. So in 2023, in the first half of 2023, they'd visited in the region of 650 odd organisations to audit their HR systems and processes. And in that same period, 271 licenses were revoked. The government has confirmed that sponsor compliance visits remains a priority in their strategy on preventing illegal working. Now, again, we have a separate presentation on this, so we can't go into this in too much detail now. But this slide will be here when it's sent out to you. Focus on these issues here in terms of internal audits of your sponsor license policies, your HR systems, and just ensure that you're ticking off that the correct processes are being carried out as per the UKVI guidance. Now, some of the visas here, the graduate route, will all be happy to note that the MAC actually recommended, following their review of the graduate route, that the graduate visa should stay as it is and that the government should not make any changes to it. The government have agreed to that, and instead what they're looking at is going after rogue education agents that are selling courses in the UK and jobs, as opposed to actual education at tier one education institutions. And the UKVI will also be looking at success rates of universities and higher education institutions, and also looking at dropout rates of international students once they're in the UK, who drop out of courses once here. So in terms of the education sector, I'd also recommend that you look at your systems from a education sponsor license point of view, because I believe audits will also pick pace in the education sector as well. In terms of the graduate route, most of you will know what it is, so I won't go into it in too much detail. Safe to say that an individual on the graduate route can carry out any type of job except for that as a professional sports person. There's no minimum hours or the number of jobs that they're able to carry out, and the only salary requirement is the national minimum wage. After the graduate route, the individual is required to extend their visa into another immigration route. If they satisfy that, then clearly what graduates will be looking at is hopefully sponsorship under the skilled worker route. I think another potential visa that may make a comeback is the government authorised exchange scheme. What the GATT scheme, as it's known, is basically a scheme that is generally governed by an overarching body. So an overarching body will have the sponsor license, and it will allow a UK employer to employ someone that's being sponsored by the overarching body under a government authorised exchange scheme. I'll ask Andy to share with you Appendix N, which has a list of all the current schemes that the government have approved. And generally, basically, a lot of schemes fell away when the graduate route came in, because it took away the salary requirements, the higher salary requirements under the skilled worker route. But it is potentially something that allows certain organisations to benefit from. So, for example, if you're an optometry business, so let's say if you're Vision Express and if you train opticians, so once a optician has graduated, they then have to do a year's training in industry. So the General Optical Council will have will run a scheme which will allow Vision Express to employ the individual under the GOC scheme, sponsored by the GOC scheme, in order to carry out that training. And then after that training has taken place, Vision Express could then potentially sponsor the individual. Again, I think within certain accountancy graduate roles and tax graduate roles, the going rate salaries and the length of sponsorship might mean that the graduate route isn't applicable, and therefore a combination of because it's only for 2 years, and therefore a combination of the graduate route for 2 years and then 1 year of a scheme, say, but for example, by the Institute of Chartered Accountants, to allow someone to complete their qualification, may be a scheme that the government might approve as well. Generally, schemes that relate to research, fellowship, and training in the fields of science and medicine can allow someone to be sponsored for up to 24 months under one of these schemes, and all other non-science-based schemes, someone could be sponsored for up to 12 months. The salary will be governed by each scheme so long as it does not fall below the national minimum wage. and the individual can only carry out the job for which they've been sponsored, plus the additional 20 hours supplementary employment. They're able to bring their dependents, and dependents can work in the UK without requiring sponsorship. And most of the cost that's applicable to this will be met by the employer that's benefiting from the sponsorship of the individual under the government authorised scheme. If someone is on the government authorised exchange scheme, they are able to switch to the skilled worker route. Another visa that might be applicable is the Global Talent Visa. There's two types of visas. There's those that are recognised as leaders in their field, and for those that are another type of endorsement for those that are regarded as emerging leaders. It must be in one of these fields of work. And generally what we advise is that if someone's going to be applying for an emerging leader, they must have no more than 5 years work experience, prior work experience. And for leaders, they can have up to, it must be a minimum of 5 years work experience. The first step for someone to apply under the Global Talent Visa is to obtain a endorsement from one of the UKVI approved endorsing bodies. Quite a popular one is Technation for digital technology for individuals, be it emerging leaders or leaders that are looking for endorsement, for example, as software developers within the AI cryptocurrency space and similar sort of new technologies. We recently did one for a fashion designer from the US, where the endorsement application went to the Arts Council. But then what a number of these endorsing bodies will do is give it to another organisation on their behalf to look at it. So the fashion application went to the British Fashion Council to look at and to endorse. Once the individual is given an endorsement, if they're a leader, they will be able to apply for indefinite leave to remain after 3 years. If they're an emerging leader, they will initially be given status for 3 years, will need to extend it for another 2 years, and then after 5 years, they can apply for permanent residence. Once on a global talent visa, an individual can work for an organisation, or they can consult, or they can set up in business, or they can do a combination of all three. Also wanted to highlight the Youth Mobility Scheme. This scheme's been expanded in January 2024, and I think it will continue to be expanded as the UK begin to sign more trade deals around the globe. If I recall, when the Youth Mobility Scheme was first introduced, the only countries that were on the scheme were Australia, New Zealand, and I think Japan, though don't quote me on that. And since new trade deals have been signed, more countries have been added to the list. The India scheme is known as the Young Professionals Scheme. So nationals of these countries who are aged between 18 and 30, or 18 and 35 if from New Zealand, Australia, Canada, and South Korea, are able to apply for one of the ballots that open. So each country will be given a certain number of ballots that nationals of those countries can apply for. The ballots open every January and then again June or July. So the individual has to apply for the ballot. The embassy will then randomly select individuals that have been successful in the ballot to go to move forward to make their application for visas under the Youth Mobility Scheme. Everything else is really here in terms of what the criteria is. Safe to say that the individual can, once in the UK, they can work in any type of employment. It's not just restricted to their particular field of work or expertise, and they are able to switch to the skilled worker route or other visas that they might be eligible for once in the UK. Interesting point here to note is that the UK and the EU are currently in negotiations to have a reciprocal type of youth mobility scheme between the EU and UK. The negotiations have currently stalled because the UK want to sign individual trade agreement, individual mobility agreements with each country separately in the EU, whereas the EU want the UK to sign this with the EU as one block. So we'll see where that goes in terms of future negotiations. But again, it's going to be one way where the UK are looking to encourage skilled labour to come to the UK for work experience and contribute to the UK labour market. So we're in the home straight now. And just a couple of slides on discrimination. And the key point to note here, both from an employment law point of view and in terms of UK VI best practice, is that a business can't refuse to sponsor a migrant because they require sponsorship. And the Home Office's own best practice on recruitment is that refusal must be based on merit, i.e. that there's a better candidate than the individual that you refused to take forward in the recruitment process. And that right to work check should happen later on in the recruitment process. Clearly, look, there are going to be exceptions to this. This isn't a full list. There may be other examples that might be applicable, but these are the ones that came to my mind when doing this slide. So, for example, if your business works in national security, in military defence, you may have a contract with the government that states that you're unable to employ foreign nationals or nationals from a particular country. If you don't have a sponsor license and you advertised a role and someone's applied for that role who requires sponsorship, and the purpose of you advertising is to recruit someone with the relevant skill to deliver a time-critical contract to your client or customer, I think you've got a reasonable excuse there to say why you're unable to proceed with sponsorship. If the skill level for the job is below that for which a skilled worker visa will be issued, that's a good enough reason. If the salary that's on offer by you for the job is below that for which a skilled worker visa will be issued, something that the likes of KPMG, etc., have come out with and saying, in the public domain, it's a good reason to say why you're unable to sponsor someone. And if someone requires sponsorship, but that there isn't enough time to acquire a license before the migrant's leave expires, or to assign them with a certificate of sponsorship, apply for a defined cause or an undefined cause before the person's leave expires. There may be other reasons, but these are some of the exceptions. And in all other cases, you should really be looking to see how you can refuse a job applicant based on merit. The leading case on this is still Osborne Clark, which is a law firm actually who lost their case against Purifit, who represented himself, who wanted a training contract in 2009, when it was the old work permit regime, but the law still stands to be the same. And to read the key paragraph that I see from the employment judge's decision is this one here. So eligibility to work in the UK should be verified in the final stages of the selection process rather than at the application stage to make sure the appointment is based on merit alone and is not influenced by other factors. Depending on the employer's recruitment process and the type of job being filled, candidates might be asked for the relevant documents when they are invited to an interview or when an offer of employment is made. Employers can, in some circumstances, apply for work permits, skilled worker sponsorship now, and should not exclude potentially suitable candidates from the selection process. And I think generally, the larger the organization, the resources that you have in terms of finances, the number of people that are working in HR, you've got the recruitment manager, the recruitment assistant, HR director, so forth. The more you're going to have to justify why recruitment isn't applicable if one of the exceptions that I've highlighted or another applicable exception is highlighted as to why you're not taking someone's interview forward based on merit alone. And so what we would advise is that by rejecting the UK nationals at the beginning of the application process without considering merits and suitability for the role on offer leaves an employer open to a potential race discrimination claim, and you need to be prepared to justify your position later. Now, look, we also act for somewhere in the region of 14, 15 universities as well. And quite often we're invited by universities to do similar type of presentations as what we've done to you for their international students. And to international students, we will say that it's important that if they reach an obstacle at the recruitment stage, to try to get written feedback as to the reasons for the rejection, so that they are clear that a valid and proper reason is given, and not just one that is based on the individual requires sponsorship, so we're not going to proceed with the application. I hope that's helped. It's been a whistle-stop tour through the changes that have happened and may happen. Certainly, we have time to open this up to questions. We have 10, 15 minutes, or as long as you want to be on the call. We do have our contact details there if you do want to connect with myself and Kieran, if you have a specific question that you may want to raise that you don't want to ask here, or if you want to connect with myself and Kieran either on LinkedIn or sign up to any of our newsletters. Kieran, any questions, or if anyone has any questions? I'm going to end the slideshow now as well.
Okay. Right. What I'm going to do is, the questions are quite varied in terms of what is being asked. We've got a few still that are outstanding that I will respond to. There is one where, and I just wanted to clarify this. So this is the question and answer one. I think that there was one question which basically said that the figures on the this is a bit more difficult to explain. So on some TEL slides, it's got a minimum figure of 30,960 as the general salary, and then it says or 80% or 70% of what's the going rate for the occupation code. So we're not saying that it's 80% or 70% of 30,960, or that if it's 38,700. So you've got two separate sets of salaries. So I just wanted to clarify this for the slide. So the salary on the slide, so you've got one general salary, then you have a second salary, which is the going rate under the code. Any percentage reductions applied to the overall going rate under the code, it's not necessarily the general salary reduction. So that's why it's not necessarily that the slide's got an error on it. It's more that it's relating to a separate figure. But if you have further questions on that, I'm happy to deal with them. Okay.
Do you want me to bring the slides back there, Kieran, to explain that, or?
Well, no, I mean, we can do that, because I think if you have a read of it, but obviously because you can't figure out what the salary is going to be just by looking at the general salary, you have to have an understanding of the code in order to be able to figure out what it is. So do intergovernmental organizations have quotas or restrictions on issuing work visas? No, so if they've got a sponsorship license, there's no restriction. So UKVI haven't said any particular organizations can have XYZ number of COSs that they can issue. However, each COS does have to be justified. So if they're going to be asking for COSs, so obviously the larger the organization, the more COSs they can justify applying for. Most applications for graduate roles ask for visa status at the beginning of the application. It's essentially discrimination. As a recruiter, how can we reword that question? So again, this question is coming up both from that perspective where organizations are asking, right, well, what can we ask and how do we word this? And also from students and from people who are supporting students find work who are saying, right, a lot of the applications or a lot of the roles basically say, do you have the right to work? And you're not actually able to continue any further unless you say yes. So what I basically said is, if you can apply for a graduate visa, I think it's worth to be able to say, yes, I have the right to work, because you know that you can apply and get that graduate visa independently, and you're not necessarily going to be relying upon it for being able to work for that particular organization. Yes, you will need sponsorship, but it is later down the line. So I think that you can justifiably say, no, I don't need the right to work at that particular stage. How do you want to deal with the, if a graduate program is, so the one where should we be asking about visa status at the beginning of the application process if you are a recruiter?
Best practices, no. I think, certainly what we do and what we recommend organizations is to shortlist. It's the shortlist with those that you're going to be interviewing. I think interview stage is the best place. Unless you're able to justify why you're asking for that, because, for example, you're aware that a skilled worker visa will not be issued because the salary on offer is too low.
Okay.
And so you're trying not to waste someone's time there.
If a graduate program is 3 years and a company is unable to sponsor a visa, would these be grounds for not proceeding with the application?
Say that again. Sorry, I missed that.
So the graduate program is 3 years, the company is unable to sponsor. Would these be grounds for not proceeding with an application?
I need more information why that be the case. Are they saying that it's a 3-year graduate program?
Yeah,
Why,
I think
can't the employer sponsor? Why can't the
think
employer? Yeah, go on.
I think that the response there would be, would it be reasonable to expect that particular employer to apply to join the SMS? If you can justify why you could not apply to join the SMS, or it's not reasonable to expect you to do so, because what you could then potentially do is have somebody on a graduate visa working for that employer, and then at the end of the last year, they would then have to say, well, we're unwilling to join the SMS for XYZ reason. So I think that the issue comes in at that point. Is it reasonable to expect that employer to join the sponsorship management system?
Based on that scenario, yes.
Okay. Re above, so potentially an international student could apply for a graduate visa, but would need to understand that skilled worker sponsorship would be required beyond the 2 years. If so, I'm interested in understanding employers' thoughts on this.
So an employer that wants to share their thoughts.
I'm going to unfortunately just continue. I just wanted to be able to get through these. As a large employer, we have a number of graduates employed prior to 2nd of April 2024, whose graduate visas expire before the end of their graduate scheme, and they will not meet the salary criteria for a skilled worker visa. Is there anything in the interim arrangements that enables them to remain employed? No. Tal, can you think of anything?
No, because they're on a graduate visa at the moment, aren't they? Yeah.
If unfortunately you're certain that that the salary can't be met, and that for the purpose of sponsorship, then no, there isn't anything else that I'm aware of.
The interesting point there would, however, be if the individuals were taken on a graduate visa before we knew that these 4th of April changes were going to happen. So, businesses forward plan here, don't they? Their talent. And it was with the assumption that at that stage they knew what the going rate salary would be. There's potentially an argument there. With the UKVI. It's certainly an argument that needs to be put to the Migration Advisory Committee. But it's similar to whatever the global talent visa was prior to in its previous name, where people weren't allowed to apply for indefinite leave to remain because they changed the goalposts, and therefore they challenged it in court, saying that we were reliant on a previous rule. It's something to look at.
Okay. Is not being eligible for a sponsorship license a reasonable justification as to why a candidate requiring sponsorship cannot progress through the process? I'm not sure what's meant not being eligible for. So if you mean not being eligible for sponsorship, yes. So if the salary that you're looking to pay someone is lower than what you'd be required to pay them for the purposes of sponsorship, then yes, I think you can say that is a justifiable reason as to why you're not going to put them through the process. Because even if you were on the SMS and willing to sponsor that role, you wouldn't be able to sponsor for. Is it reasonable to refuse on a 3-year graduate program if skilled worker visa can only be offered for 2 years as new entrant, and we know they can't complete the final year and wouldn't qualify? So you have a 3-year graduate program, and they refuse to sponsor based upon the fact that they were only going to be able to offer them sponsorship for a 2-year period as a new entrant salary. They will not be able to afford the salary for the 3rd year. because they will not be able to benefit from a new entrant salary.
I think they have a justification there.
Yeah, because what you're basically saying is the salary range is outside of what you would be able to pay them, which is one of the grounds. Would there be grounds to renege the offer as the graduate currently has right to work, even though they will lose it mid-scheme? I think we're getting into the territory of employment law now, and so I think my advice would be, whilst technically you could say we can't offer you sponsorship, could you end this early now based upon the fact that in the future you can't be offered sponsorship? And I am going to say I do think that we are getting into the territory of employment law, and that's something that you would need to work out with taking into account employment law as whether or not you can terminate employment early, knowing that a year or 6 months down, you're not going to be able to continue at that point. Bearing in mind the overlap period, time taken that they might need to be able to find alternative employment, impact to them, etc. Okay. My question is, Satal, I'm going to get this one over to you, and it might be outside the remit of that, which is absolutely fine. Then the person can just scan the QR code and email us directly. My question is different from what was discussed today. It is regarding global talent visa. Can a current international student in UK apply? So that's a yes. What are the requirements? Again, that's going to be too broad for this. And what is the process? So in terms of requirements and process, I will be honest with you, in the first instance, you can get a general overview from UKVI's website. So UKVI's website will give a very general overview. I appreciate that quite often it's not very specific, and I appreciate that it doesn't necessarily relate to individual circumstances. And so once you have a basic idea, what I would say is at that point, have a meeting with a legal advisor who can go through that with you, but applying it to the facts of your case and what exactly you can submit and what you can do, and add in what their experiences are. So I would get some general information and then try and get an appointment with a legal advisor.
Sharon, we're being asked to wrap up.
Oh, okay,
by
sorry.
The powers that be.
Okay, I have a few more questions, 2 more, but I'm going to leave those in the hope that somebody will email us if they've got those questions.
Yeah, look, certainly, Sarah, if you're able to sort of collect these questions for us and give us a bit of time, we'll wrap it into an FAQ for you as well.
That was going to be my ask, actually, because we can absolutely share all of the questions that have been not answered. Wale can take care of that for you as a file afterwards. And it would be lovely to have a follow-up of key points. You've covered so much. I mean, that was more than a whistle-stop tour. And thank you, Karen and Andy, as well, for getting through as many of the questions as you possibly could. Thanks for the engagement, everybody that's still on the call. I know people are dropping off. A lot of technical information, clearly a lot of homework for everybody to be doing, both in employers and for our university colleagues to share with your international students. So we will leave it there. A massive thank you again to you all for supporting this. We may end up with another one in the future. Who knows what's going to happen after the 4th of July and what other future changes there may be. So watch this space, everyone. But have a wonderful rest of your Tuesday and rest of your week. Thank you.